Good afternoon everyone, and welcome to the fourth talk in the Land Rights Initiative speaker series. I want to start by thanking our speaker for today, Mr. Venkatesh Nayak, for taking the time to come out and speak to us about his work, and all of you for taking the time to come and participate in this conversation. I also want to thank Pragya and Ankit, who are working with the initiative and have been instrumental in putting together this talk. Before I introduce our speaker, I want to say a few words about the work that we are doing here at the Land Rights Initiative and the broad objective that we had in mind when we designed this speaker series. So the Land Rights Initiative is actually the CPR's newest initiative. We launched it in November last year, and the goal behind setting this initiative was essentially to build systematic knowledge, both archival and field-based knowledge, on land rights issues in India. The initiative is currently housing two projects. The first project, which we call the Land Rights in the Scheduled Areas project, we are studying the legal regime governing rights to land of the tribal communities as well as other communities living in the scheduled areas of India, with a particular focus on the states of Andhra Pradesh, Telangana, Gujarat and Meghalaya. So both 5th schedule and 6th schedule states. In the second project, we are exploring conflicts in land acquisition by the state by studying a database of 2,500 Supreme Court cases on land acquisition that have been decided since 1950 to the present. Essentially, we are going to classify this database of cases according to a number of inputs, with the goal eventually of systematically presenting data on causes of land conflicts in land acquisition cases, as well as the trends that we see across different states. So that's about the initiative. Now, our goal behind the CPR Land Rights Initiative speaker series is essentially to hear diverse perspectives from multiple stakeholders working on these issues, including academics from various disciplinary backgrounds, grassroots activists, policymakers, and researchers in other civil society organizations, with a view to generating multidimensional and multi-stakeholder knowledge on these issues. So on that note, I'm very pleased to once again welcome and introduce Mr. Venkatesh Nayak. Venkatesh, if I may, is the program coordinator of the Access to Information program at the Commonwealth Human Rights Initiative in New Delhi. Venkatesh's work has in the past focused on ensuring greater transparency in the functioning of public authorities, including the government but also other authorities, with a view to ensuring accountability in governance in India but also in other countries in Asia and Africa. He is also presently co-convener of the National Campaign for People's Right to Information. So without further ado, I will turn the floor over to Venkatesh. Thank you.
Thank you so much, Namita. I must make an honest confession here. I am not an expert on issues related to land or land acquisition. So it was with a bit of a sense of trepidation that I accepted this, knowing fully well that there would be lots of experts who've looked at this subject for a long time. But what I'm going to share with you is just my experience of working on this subject. Less than a year. It's just about 9 months that I've looked at this subject, and there are some reasons also. In fact, the expert on land acquisition in my family is my father, because he was the land acquisition officer for one of the major hydel projects in Karnataka. And I remember going to his office as a kid in school after school hours were over, and he's sitting in front of a series of desks much longer than this, with a lot of project affected people sitting around and making their claims, and I had no clue what was going on then. I was just about in class 3 or class 4. Not until recently did I even think of working on the issue of land acquisition, because the organization that I am associated with, Commonwealth Human Rights Initiative, we primarily work on issues of civil liberties, human rights, particularly civil and political rights, and our focus areas of work are promoting people's access to information, promoting police reform and accountability, prison reform, and the general mandate that the organization has, which is to monitor the human rights situation in Commonwealth countries. Now, how did we get into this area of work of land acquisition? That also has a bit of a personal angle to it. Last year, when Parliament was elected, it became clear that at least for the next 5 years, we would have a government in place which is wedded to an ideology and very often practice which I have had huge problems with since my student days. I was a student at the Jawaharlal Nehru University, 1989 onwards, and we've seen how politics in India came to be shaped during those 90s, and later on a significant part of that, the government was under the control of the National Democratic Alliance. But then we thought, fine, it's a democratically elected government, so what we could best do is monitor what they're doing in those areas which are of interest to us. And when this idea was shared around, so we looked at the election manifesto, identified all those paragraphs which talked about transparency, accountability, public participation, and circulated it to our civil society network, saying that look, these are the promises that they've made, now they've got the mandate to govern, let's look at how well they fulfill their promise. And which I think any civil society organization or any like-minded media person or academic would actually want to look at. And then came a challenge from one of our own friends whom I didn't know until then, who scoffed at the idea that somebody sitting in civil society could actually monitor what the government was doing. And I don't know what actually motivated that person to make such a comment, but it was literally a scoffing remark saying that, oh, you think you can monitor? And of course, ever since, we've taken it as a challenge, and we looked at various things that this government was doing, particularly in the context of transparency, in the context of whistleblower protection, etc. Then came the last week of December, and 31st of December was the promulgation of the ordinance to amend the Land Acquisition Act. And let me tell you, until then, I had not read the Land Acquisition Act at all. That was also a time when our office goes on a winter break. And the first thing that we did was, after we reopened, and this is the first phase of my work on land acquisition, I filed a request with the Department of Land Resources and Rashtrapati Bhavan, asking them two simple things. Please tell us what materials were put before the Honorable President of India to show that circumstances existed to amend the land acquisition law. Because after all, ordinance making power is not to be used lightly or loosely. It is meant to deal with emergent situations when Parliament cannot be called into session, urgent action has to be taken, and therefore there must be some very good reason for the President to sign the ordinance. So we just wanted to know what were those reasons. And obviously the Rashtrapati Bhavan, true to its mettle, once they clear a file, they never take responsibility for it. They say it's the concerned ministry which is responsible. So the RTI got transferred to the Department of Land Resources. And the Land Resources Department said this is cabinet information, cabinet papers, cabinet notes are involved, and we can't disclose this information to you. So the information is rejected under what we call the Cabinet Papers exemption under section 81I of the Right to Information Act. Now, for many of us who are in the transparency advocacy sector, more than victories, it is the losses which are exciting. So when you don't get the information, there is more reason to cheer, because then you can escalate the matter to certain levels and get some binding orders relating to systemic transparency put in place. So we actually hope and pray very often that we don't get the information. So then you can go and have a binding order from the Commission, Central Information Commission, and that becomes a rule, and that's happened in several cases. I won't get into that because it's not connected with the topic of the day. And the second, the request that went straight to the Department of Land Resources was specifically about cabinet note. We didn't ask for materials put before the President. We said cabinet note, give us a copy of that. That was also rejected. And then the usual appeal and complaint and all of that was following. And I found out that one good friend of mine who works on issues relating to land acquisition, particularly in areas which are inhabited by members of ethnic communities, scheduled tribes, who had also made a similar request. And then there was another journalist from Mumbai who had made a similar request. So there were 3 of us who had asked for that cabinet note, and all 3 of us had been denied. And in fact, the first applicant is the scholar who's based in Odisha right now, and I think last week she published an article in the op-ed page on the Hindu, Chitrangada Chaudhary, on issues of land related to Adivasis and all of that, and developmental projects. Anyway, so we did a bit of a coordination, and we realized that there were 3 cases that were pending before the Information Commission. So why don't we just ask for the Information Commission for a expedited disposal of the matter. Now I know this has got nothing to do with land acquisition, but let me tell you what are some of the battles that we have had to go through. Thankfully, around the same time, there was a hiatus, a gap in the Information Commission. There was no Chief Information Commissioner. Many of our cases had piled up without any hearing, because work allocation in the Commission cannot happen unless the Chief Information Commissioner allocates work. That's the structure of the powers and responsibilities given in the Right to Information Act. And around that time, the Delhi High Court came out with an order saying that wherever there are matters which are of immense public interest, where the appellant might be physically differently abled, or the appellant may be a senior citizen, or there could be other public interest matters, then the Commission can always expedite the hearing. So we grabbed hold of that order, made a request to the Information Commission and said, kindly identify our files, pull them out, and please put this matter, these 3 matters before the Information Commission so that an expedited hearing could be done. It actually took us quite a few days to find out where our packets containing the second appeals and the complaints were all lying, pulled them out, got the file numbers given to them, and there was a whole a lot of advocacy that had to happen at the registries level to get the papers out and at least have them put before some commissioner for consideration. Interestingly, without naming names, the Information Commissioner whose portfolio was the Department of Land Resources developed cold feet. He said, I don't see any urgent matter in this. There is no urgency. Like somebody's life has to be at stake for them to look at it, from the point of view of urgency. So we kept that. So then what we did was we waited for the Chief Information Commissioner to be appointed, made representations. After about 8 months, the Chief Information Commissioner was appointed. And finally, there was reallocation of work. So the Department of Land Resources was shifted from one commissioner to another commissioner. And we made representations to that new commissioner also, physically meeting him and saying, sir, we don't want you to pass any favorable order just because we are saying it, but kindly rule on this issue, because we need to make submissions to the Joint Parliamentary Committee in an informed manner about the proposals for amending the land acquisition law. And we cannot do that if we don't get the cabinet note. So that was our 1-point argument. Let me tell you, now we are 6 months down the line. The Commission has still not scheduled a hearing in this matter, and now I think it will be only of academic nature as and when they decide, because as you are all aware, the land ordinance has been allowed to lapse and hasn't been renewed. So that is one stage of our work which hasn't yet reached any level of certainty or conclusion. It's still pending. We're waiting to see what will happen. The second phase was something that was completely unplanned and unexpected. And I'm a student of history, and sometimes I believe that certain things happen so serendipitously that you actually end up handling a lot more than what you had actually planned for. So in February, end of February, the Finance Minister presented the economic survey in Parliament. And let me tell you, economic survey is something that many of us in the so-called civil liberties sector, we don't really take it very seriously, because it doesn't connect so much with the standard areas of work that we are engaged in. But then it was just one weekend happening to flip through, and suddenly you came across a small table, 4.3. I don't remember the page number now, where they talked about the stalled projects. Private sector, so many stalled, public sector, so many stalled, and reasons were given. And for the private sector projects where stalling had occurred, the topmost reason was land acquisition related problems. And about 169 projects or so were mentioned there. So I read that, and still it didn't strike a bell. A couple of days later, one read a statement in the electronic media that the Honorable Finance Minister, when Parliament was in session, went to Washington DC, met with some people there, and made a statement saying that the major reason why developmental projects in India have stalled is because of land acquisition. So I thought, okay, now let's try and monitor this. Let's find out what the truth is. So it was one innocent RTI that went to the Finance Ministry asking for a list of all the projects that had been stalled, and which formed the basis of not what the Finance Minister said, but what was given as data in the table 4.3 of the economic survey. So we made a reference to that and said give this thing. And generally, like I've said earlier, we always expect that we don't get the information. So it is literally like another 5-year plan that was going to be put in place. The application will be rejected, then you do your first appeal, the first appeal will be rejected, then you do your second appeal, and then you wait for 3, 4, 5 years for the second appeal to be decided. But surprises, surprises, I actually get a request for payment of additional fee of some little less than 100 rupees, saying that the information will be provided to me if I submit additional fees of that amount. So the additional fees was paid, and then a whole bunch of papers came, which was a full list of stalled projects. And let me see if I can show that to you on screen. One moment. I'll show it to you a little later. Right now I don't have it with me here. It's on my email. I'll pull it out during the question answer session. Anyway, so there was a, I think it must be in the system. One second.
That's the stall.
Yeah. No. This is, yeah, this is it. Yes. Yeah. So this is the data that I received. So what the economic survey pointed out was just about 500 plus projects. But this information that we obtained under the Right to Information Act was for about 804. And one didn't expect this kind of detailed information being available. And let me tell you, some parts of this list of 804 projects is still unanalyzed. Anyway, so this came, and I started thinking that in my school days I never took mathematics seriously. So I don't know what sense to make of this. Kya karenge isko leke? So for almost a week, this was just lying on my desk. It had been scanned and all that, but I didn't know what to make use of it, how to make use of it. We were looking at some other, emergent matters. The whistleblower protection law was being amended in a very retrograde manner, so we were busy with the advocacy around that. And then this very young journalist of Economic Times, who keeps contacting, many of us who are working in this field, wanted to know what's the latest in terms of our interventions and what's available, if there is anything that could be done as a story. And I said, I've got this data set. I sent it to her. And apparently when her editor saw it, he told her that don't work on anything else for a week, sit at home, analyze this data. After about 3 days of analysis, she said, I'm racking my brains, I can't make head or tail of it. So can you pay some attention to it? I said, what's the point of you asking for this information? See if you can make any sense of it. And that was a weekend, so I sat and looked at it. And then I realized that we could do several kinds of interrogations of this data. The biggest was the last column, the biggest pointer. I had never expected this kind of information to come out. They had recorded it. But what really irked me was, there's this data source was not even the government's official source. This was from a private sector think tank. I mean, this is no comment on the quality of the data, but if organizations like mine were to put some data out in the public domain, we would always be interrogated for the correctness and the properness, the propriety of the methodology and this and that, everything. But here this was accepted without any questioning. Anyway, so we analyzed this, and in the course of doing that, what we found out was, out of about 804 projects, I'm sorry if you can't see it, I'll just read it out for you. Typically, the more economically developed states had more stalled projects. Maharashtra was the topper, followed by Gujarat, West Bengal. Surprisingly, Karnataka also had a lot of projects. And interestingly, Telangana, which earlier would have been combined with Andhra Pradesh, also made it to the top 5. And what we found here was that the private sector projects that had stalled were more in number as compared to the projects that were planned by the central or state governments or the local municipal bodies or autonomous authorities. And when we did a quick calculation, we found that out of 804, only 66 projects, that's roughly 8%, had stalled because of land acquisition problems. And that's what really hit the headlines. That if you are saying that economic development is not really happening, the economy is stalling, the developmental projects are stalling, and therefore you want to do amendments to the land acquisition law, then there's got to be some data to back that up. After all, Article 14 is what governs every single action of the government. It's got to be non-arbitrary, it's got to be defensible in front of the law, and it's got to be fair and equitable. Now, how can you make 8% data as the basis for amending the land acquisition law? So this is the first question that we asked. And then we went further, because the more you started looking at these kinds of things, then you started making connections with the proposals for amendment of the land acquisition law. They said there would be no need for doing a social impact assessment, and state governments could waive that requirement in about 5 or 6 different categories of projects. And that was passed through an ordinance. So how many of these projects fell into those categories? And there again, what we found was only 11 projects actually related to the well-being of the disadvantaged or the less affluent segments of society, such as low cost or budget level housing projects or construction of a bus stand, those kinds of things. But in quite a few of the stalled projects, about 18% of them, 145, what we found that was majority of them were again the private sector, all right, but then they were about construction of shopping malls, elite hotels, and a couple of golf resorts, and one racing track also. We were not making any comment on the data, we were just putting the data as it showed up to analysis when we looked deep deep into it. And what was even more worrisome was that as many as 19% of the projects did not even mention a specific reason as to why they had stalled. And further down, 15% of the projects, about 121 of them, nothing was mentioned there as to why they had stalled. Others was also not the category. It is blank, as you can see here. Not available. Others not available. Others not available. And what we found was that a large number of projects had actually stalled primarily due to unfavorable market conditions. A very small number had stalled due to lack of environmental clearances. Quite a few had stalled because of lack of adequate availability of raw materials. And that is when, generally one gets a little cheeky when one sends out these email alerts. And one was reminded of this very famous meme that was part of Bill Clinton's presidential campaign. He actually said the economy is stupid. He said it's the economy stupid. First, try and locate the real reasons as to why economic development is not happening. Don't blame it on land acquisition. Your own data, on the basis of which you are trying to sell the idea of why the land acquisition law has to be amended, that's not being borne out by your data, and there are other reasons for it. But what we were not very sure was that this data was available, as the list itself indicated, was up to about February 2015, just around the time when the finance minister had presented the economic survey. So this is not something that I have written. This is what the Public Information Officer himself released, saying as of February 2015. So this is a little more current than what was quoted in the economic survey, because that was just about 500 plus projects. This is about 804 projects. About a month later, this journalist friend of mine contacted CMIE again, and the stalled projects had risen to about 1100. Although the rate of stalling apparently had been going down, but then the absolute numbers had gone up. So this was anyway picked up by n number of people, and the media highlighted it in the electronic media in print form, on television. And what was interesting was something that we were getting ready to face as a flak was government discrediting this data. That did not happen. There wasn't a single statement issued by any minister or bureaucrat in the media saying that this data is nonsense, this is not credible, this cannot be depended upon. Simply not there. And then of course we did the usual circulation of this data to all the major political parties, just to tell them that look, this is what the data is showing. If you want to make use of it, please make use of it. And eventually a couple of notable faces in parliament did make use of this in their speech, and anyway, that's now history. Any of you who look at the debates of what occurred in the Lok Sabha, you would see some reference to this there. So after that we thought, we were still struggling to get hold of those cabinet papers and nothing much happened. We were struggling with that, and then something fortuitous happened. My office compelled me to take about 5 interns from various law schools. Generally, we have very small teams. Right now my team is just about, there are 3 of us working. So we had 5 extra. Very bright, very brilliant young girls and 1 boy. And I have this bad habit of looking through Gazette notifications every week, when one is bored, just to see what's new. Thoda sarkari akhbar pad lete hain. And something I saw something which I hadn't noticed earlier was that in the extraordinary part of the Gazette, which gets published any which time the government wants it, it's not a weekly thing, it can come any number of times during a day or any number of times during a week. We found that there were notices about various ministries that were acquiring land or were declaring their intent to acquire land. And since we had this army of 5 interns, apart from teaching them about RTI, because that's the basic reason why they come to CHRI and work with our teams, we said, look, part of this will be your learning about what is meant by RTI, but then part of it will also be hardcore research. So would you be interested? And they really took to the research like fish takes to water. And what we decided was that we would look at all Gazette notifications available on the Government of India e-Gazette website from 1st of January to the cutoff date, which is 30th of June, to see how many ministries under Government of India have acquired land under the ordinance or under the 2013 law. Because if the ordinance has been passed, there is an urgency, rules have been made under the 2013 law to some extent. So obviously one would expect that they would use those provisions to acquire land. And then because the ordinance brought those legislations of 13 other ministries, which empowered those ministries also to acquire land for public purpose under the provisions of the land acquisition law for the purpose of calculating compensation and determining relief and rehabilitation schemes. So they were all under the law. So one would reasonably expect, the hypothesis was that one would reasonably expect these ministries to acquire land under the Act as amended by the ordinance. But then again, evidence is required. So we started and looked at about 500 plus, 504, 505 Gazette notifications that came out during this 6-month period. And to our biggest surprise, now let me pull that email alert out on screen. sorry, one second, it's not brick building, it's yeah. So we looked at about 505 gazette notifications. These were primarily issued by the ministries of Road Transport and Highways, Railways, Coal and Petroleum and Natural Gas. And we divided them into two categories. First was where the process of acquiring land had been to a certain extent completed. So where the government actually declared to the gazette notification that henceforth we acquire this land and it will be free of all encumbrances, which means they are taking possession. So we call that notice of acquisition. Now these are all terms that we couldn't actually find in either the land acquisition law itself or anywhere in those categories. And many of us are not even lawyers, those of us who are working on this. And when we talk to some other experts, by now we realize that we need the assistance of some experts who've made a career working on issues of land acquisition. And thankfully, one of my mentors on RTI is herself an expert on land acquisition. So we sat and discussed with her, and she explained to us what was the difference between the 1894 law and this new law. And we realized that there were no terms of art that we could use existing in the present terminology. So we said, let's cook up something so that people easily understand. So wherever the government had only said, we want to acquire this bit of land, anybody has an objection, file your objection by so and so date. So we call that notice of intent to acquire. So we called it NOAs and NOIs so that it will be much easier for us to do an analysis. And we did the analysis for this 6-month period, and what we found was that these 4 ministries had acquired land in about 1500 odd villages in 263 talukas across 141 districts in 22 states. Not one of them was under the 2013 law. Every one of them was under their special law, the National Highways Act, the Railways Act, the Coal Bearing Areas Act, and then that petroleum and natural gas that mines minerals and pipelines, that acquisition of right of user in land. All acquisitions were being made under this law. And what we found interestingly was that in 2 cases where the developmental projects where land had been declared as having been acquired, they were in Schedule 5 areas. And there is no mention anywhere in the gazette notification as to what the objections were like, how many people filed objections. In fact, what we tried to do was, but then we gave it up midway because it was becoming very difficult even for a team of 5 to handle it. Now against each plot of land, many of the gazette notifications, either the intent to acquire or the declaration of the fact that they've acquired the land, there were thousands of people who were named. Now that is one bit of analysis that hasn't yet been done to see how many of these people have been affected by these linear projects. Now very often, from my limited understanding, what I have seen is land acquisition becomes a huge problem when large swathes of land are acquired. There's major displacement, there is major lacunae in the relief and rehabilitation, and therefore there's a lot of suffering, and that becomes a big issue. But in linear projects, small parcels of your land are taken. So you retain the rest of your land, but only that portion which is required for the purpose of construction of that road or the railway track is taken away. And again, a little bit of a personal connection with that. My paternal grandfather lost some of his lands that way for the construction of what is called the Mangalore-Hassan railway, the broad gauge track. And what we experienced at that point of time was the pittance that was given as compensation, and the fact that that bit of land is no longer available for you for cultivation, it creates havoc with your economic situation. Now this is something that I don't think has been adequately studied, that when you take away small parcels of land, let's say from marginal subsistence or small landowners, what impact does it have on their lives? Is the compensation enough for them to get by for the rest of their available lives or for the rest of the generations. Now this is something that has not been studied. And what we saw was that in many of the villages where this land was being acquired, large portions of such land were actually privately owned, irrigated land, cultivable land, and some parts were government owned or non-cultivable land. And it was also a big difficulty trying to understand what the terminologies were. Haryana mein, there is some terminology. Odisha, there is some other terminology. West Bengal, there is some other terminology. So to make sense of what kind of land you actually were acquiring, and some of these terminologies are not easily explained on internet sources. And given the short period of time within which we had to churn out this research, we didn't have the luxury of contacting our friends in those states to get hold of the copies of the land records and all that, and finding out what exactly was the meaning of some of those terms that was being used. Like for example, ghair mumkin land. Now ghair mumkin, for somebody, a South Indian like me, who's just about learned Hindi after having come to Delhi, means something completely different. But it is a revenue term. Sorry, it's a term of art used in relation to issues connected with land. Banjar Zameen we thought was just barren land, but no, Banjar Zameen has a completely different meaning in law. So we looked at that and said, okay, now we can't sit and classify all of that information just the same way as we cannot classify the names of people who are all involved. So we will just say, looking at one specific notification, majority of it, is it privately owned, is it sarkari, is it community owned, like a pasture land or whatever. So that's what we said, mostly this, mostly that. And this information was also put out in the public domain. And the media again covered it in a very big way. And eventually, what was pointed out was that you amended the law on land acquisition with such great urgency, justifying all around the world, not just in India but also elsewhere in the world, that this is absolutely crucial. And then your own ministries are not acquiring even a cent of land under your amended law. You're still going ahead with what the sector-specific laws that they have always been using. So this is where this research stands. And now the fourth part, because generally one doesn't like to leave these things halfway down. So the fourth part of the intervention now has been something which again we think is within our meager capabilities, and something which we cannot really we don't really need to get engaged with experts to work on this. As a rule, in all the notices of acquisition of land where the government said henceforth we are acquiring this free of all encumbrances, they made two statements. This is the competent authority for the purpose of land acquisition has submitted his report to the government on that whole acquisition issue. And then in a majority of cases, wherever that information was available, again, where it is available is a small number, but out of that also a majority, the notification said 12 objections were received, they were rejected. 5 objections were received, they were resolved. Now what was this objection about? What was resolved? How was it resolved? And who got how much compensation for that land, that parcel of land that was lost due to these projects? So in the fourth phase, I filed 2 information requests, one with the Ministry of Highways and Transport, Road Transport, and the other with the Ministry of Railways. And now we're very careful, because we've had this experience earlier with Income Tax Department, where one RTI snowballs into a plethora of replies. And I think the last time I got some replies about some other topic, there were about 500 envelopes coming from various income tax circles. So we didn't want that to happen this time. So I said, please don't send us any hard copies. Under the category, the form in which information is required, we said, please put the copy of the competent authority's report on your website, and put the details of the beneficiaries of compensation on your website, and just tell us the URL. But then we propose, and the great biggies dispose. They still made multiple copies of the RTI application. The Railway Ministry sent it to all the railway zones, and now all the railway zones have sent it to the divisions, and I am landing up with piles and piles of information, which is nothing but transferring the RTIs to various authorities. It's literally like some of these PIOs are running around like headless chickens, not knowing what to respond. So now I've done my first appeal again, being a sensitive, socially sensitive and a responsible citizen, taxpayer, voter, saying that please, I don't want to be responsible for so much of government resources being wasted. Because what happens, they send me a response and then 5 copies of that go to various other officers to whom that information had earlier been sent. Huge waste of public money. So you said, please put a stop to this. The appellate authority is the executive director of the railway board. You are high enough an authority. You please look at the validity of my request. And I connected it with a specific provision of the RTI Act which says that whenever you announce important decisions to the people, place all the facts in the public domain. Which means how much compensation you pay to those people, what was contained in the Land Acquisition Authority's report. Put all of that in the public domain. Tell us the URL, we'll make use of it. Systemic transparency. Same thing has been done with the Ministry of Road Transport also. Replies are still coming in. Last week I was down with viral, so I couldn't open up the envelopes. This week onwards, we'll be looking at what the responses are like. But this is where the 4 stages of my intervention as far as land acquisition law is concerned. This is where it is. We are still not letting go of the cabinet note wala intervention. We want to fight that to the very end to find out why this proposal to amend the land acquisition law was required. Oh, there was a small element in between that. One department did send me the Department of Land Resources sent me some information. They said no cabinet note, but we will give you copies of all the representations received from various state governments against the 2013 law. And that was then analyzed by this journalist friend of ours, and she pointed out in how many cases Congress ruled states had made what kinds of submissions. And then that was put in the public domain. And then they all came back and said, no, this is a completely twisted version of what we actually said in the meeting. Whereas the actual minutes of that particular meeting have been withheld under RTI. So that is still the subject matter of the complaint before the Information Commission. We are still waiting for a decision on that. So the whole purpose is something that, again, let me come back to why do we ask specifically for cabinet notes? Cabinet notes basically contain the justification for any decision that is approved by the cabinet, number 1. And number 2, it also contains the gist of the discussions that have happened between different ministries that are engaged in that particular decision making process. Now, under the rules of cabinet procedure, which incidentally are themselves confidential. So today, the only copy of the rules of cabinet procedure published by the Government of India, marked confidential, so every copy is numbered, one copy is available outside of government with me. Because I managed to fight and get that rule out from the Central Information Commission, they finally ordered that the rule must be made public. They have still not put it on the public domain and it's not available on any website. I make use of that in several of my RTIs and say, I'm in legitimate possession of a copy of this, numbered so-and-so, released wide CIC order in so-and-so case, dated so-and-so. Because you do not want to be prosecuted under Official Secrets Act for possessing a confidential copy of a document. Anyway. So that rule actually says that whenever a subject matter of a cabinet note on which cabinet's decision is sought, if it affects the working of more than one ministry, then all those ministries must be consulted. Their views must be taken on board. And the information that they give during the consultation, that should be tabulated and annexed to the cabinet note. So that way you get to see what was the benefit of the advice that the cabinet had at its disposal before it took a decision on any matter. Then, January 2014 onwards, a new pre-legislative consultation policy has been adopted by the Government of India, which says that whenever you want to bring in a new law or whenever you want to amend an existing law, once the concerned nodal ministry is reasonably satisfied with the draft of that law, they are required to place that text in the public domain and invite comments from people during a period of 30 days. Those comments should then be tabulated, incorporated into the decision making process and annexed to the cabinet note, and later on when the bill is tabled in Parliament, then that set of comments from the people should also be given to the standing committee which vets that bill, which means that participatory process. That's another long story where several years of persuasion of the government of India eventually resulted in that pre-legislative consultation policy being adopted. Nowadays it is being honored more in the breach because there isn't much pressure from civil society for pushing that particular button, saying that all laws must go through this consultative process. But anyway, so the advantage of getting a cabinet note is to see not only these kinds of things, but also some of the gems that are handed over to the cabinet ministers as advice. And one such gem is again something that came out quite unexpectedly in the context of whistleblower protection law. We asked for the cabinet note behind the proposals to amend the whistleblower protection law, which we think are very retrograde. And the cabinet note actually said it in two places that citizens of this country cannot have an absolute right to blow the whistle against corruption, especially when it relates to matters of national security. Now this is something that you and I will never get to know unless it is either leaked by somebody in government or it is obtained under the RTI Act. Now how can you as a civilized country, having for a national motto Satyamev Jayate, say that citizens cannot have an absolute right to blow the whistle? And this is not blowing the whistle in the public domain, my friends. This is blowing the whistle in confidence to a statutory authority that will inquire into those complaints in confidence, not making anything public until the last point is reached. So this kind of reasoning is something that you actually get only in the form of cabinet notes, and of course in the form of file notings later on, when one expands it to that. File notings of various officers who are engaged in the decision making process. So that was the purpose of the whole RTI intervention, and we are still waiting now for the decision of the Information Commission on that. Just yesterday one of our friends has again sent a reminder to the Central Information Commission saying now this matter has become completely academic because the proposals to amend the law have been withdrawn. The law stands as it is. Of course, there's a big confusion as to what the law stands as it is now, but that's a different matter. But now the cabinet note is no longer sensitive because the matter is completed and over, the ordinance has lapsed. Now we are only asking for a copy of the cabinet note that was related to the ordinance which lapsed. Give us a copy of that, at least let us debate it publicly. But God knows when the commission is going to decide this case, so as and when that happens you will get to read about it in the papers, of course. So I think that's where I'm going to end my presentation. I'm sorry, this is not a structured presentation of the kind that CPR is normally used to, but this is again the crazy way in which some of us have been working on this, and that's reflected in the way I've made the presentation. Thank you.